Good morning. Happy Monday. Jeff Gray is one of the few auditors that I could stand to watch. He is, in my opinion, this is all just my opinion, your mileage may vary. He's a good auditor. He picks issues where he is clearly in the right, where the officers don't have a leg to stand on. He documents the before and after pretty well to make sure that, he doesn't, throw shit all over the place and then turn on the camera as soon as the cops come and then pretend to be innocent. He's maintaining himself with good composure throughout. In my opinion, of course, your mileage may vary. And I've always shaken my head as a matter of law, his belief that by telling the officer that what he's doing is constitutionally protected somehow strips the officer of qualified immunity is baffling to me. I have yet to see a single case where when a suspect tells an officer that they have a constitutional right to do said thing, that would somehow strip the officer of qualified immunity. And what does strip the officer of qualified immunity even mean? I don't even know if Mr. Gray has a very good understanding of what qualified immunity is, what its intention is, and how it works. Because he posted a video where Solo Yacker, who is a Second Amendment advocate, who carries a rifle to go to and from fishing, he posted a video of the body cam footage of the officer who arguably detained Solo Yacker for what is probably about 2 whole minutes before saying that Solo Yacker was free to go. And then there's the radio chatter back and forth before and after, which I don't understand what Mr. Gray thinks is actionable there. So anyway, but it's end qualified immunity is the thumbnail, and it's the ending credit, I guess. I don't know what you'd call it. Well, the way qualified immunity works is it number one, you have to sue a cop. Well, I mean, when we're talking about police, I should say, because qualified immunity goes for a whole host of government officials and agencies and things like that. But in order for a cop to assert qualified immunity, and a cop does have to assert it, number one, you have to sue the cop. And it has to be something that he's been doing in his official capacity. So, like, if you sue a cop for breach of contract, he can't assert qualified immunity. But if you sue a cop for unlawfully arresting you or something like that, then he would be able to assert qualified immunity. Qualified immunity is basically a defense. It's like a anti-SLAPP statute. It's a quick way. It's designed to be a quick way to weed out losers, to weed out loser cases. That's the legal intent behind making qualified immunity. If you think of a spectrum, 0 to 100, where anything above 0 up to 33 it looks white to the naked eye. It looks white. So there's nothing there. There's nothing in it for the plaintiff to recover from. There's nothing there from 0 to 33. A third of all cases, there's nothing there for the plaintiff to recover from. It's settled law. There's just nothing there. Those, when challenged, they go once the cop asserts qualified immunity and the plaintiff has the burden to prove that there's something he could win on, those go away. And that saves the cop money. And the cop shouldn't be spending that money because, again, it's a loser. It's a loser for the plaintiff. And it's a winner for the defendant. So the cop shouldn't be spending that money. Just like Just like, think about it this way: should someone be? This lady's having a hell of a time parking. Never buy more car than you can drive. Should a suspect be detained and then arrested and then hauled down to the jail, booked, spend the night in jail, see the magistrate, only to find out that there's no probable cause? No, they shouldn't. And at the earliest opportunity, the suspect in a criminal investigation should be released, right? We agree on that. The same thing in a civil lawsuit. At the earliest possibility, the defendant, once it's clear that the defendant is going to win, should be released. So that's like the best case scenario for qualified immunity. She managed to get in there. It's not a big car either. Anyway. And then you have that middle 33%. So anything above 33 and below 60 or 66% and below. So that full third in there, 66 and whatever. You know, there's percentages. Roll with me. John, you're wrong about that. You cooked it up. It's 33 and a third, 66 and 2/3. You've cooked it up. Anyway. So in that middle third, that's where you see it go. So you start detecting shades of gray, right? That's where somebody could reasonably see that there was a problem or not. I mean, it's debatable. It's a gray area. That's what gray areas are. They're debatable. And the court then has to look to see, has there been a line drawn? Has there been a line drawn? Because on this particular issue, we've just determined that it could go either way. A reasonable mind can differ. A reasonable mind can say that this was right for the officer to do. A reasonable mind could say that this was not right for the officer to do. So if where reasonable minds can reasonably differ, then what you need is a hard, bright line. You need something that you could hand to officers and say, look, this is where the line is. As long as you stay on that side of the line, you're fine. Once you go onto that side of the line, then problems. And so that's what Turner v. Driver did. Is Turner v. Driver took an area that was gray. Could they have arrested him? Well, it's a gray area. They didn't arrest Turner. Could they have detained him for filming? I mean, was there sufficient probable cause, or was there sufficient reasonable suspicion, I should say, to detain him for that hour or so that they detained him? And the court said, it wasn't settled yet. Reasonable minds could reasonably differ. I'm paraphrasing, obviously. But at the end of the day, here now is the new line. There is now a line that unless there are reasonable time, place, and manner restrictions that the officer can point at and say, I thought it was one of these, then there is no restriction on filming in public. So that's the gray area. And then you have the final third, the 66 and 2/3 on up to 100, where it's black. It's just there's no reasonable way, or there's no way a reasonable person could think what the officer did was right. There's just no way. And that's where you get into the Taylor v. Riojas. It was the recent Supreme Court decision. Everybody thought, oh my God, this is going to end qualified immunity. This is amazing. And it doesn't. It just says that, we're not dealing with an area where the defendant's going to win. We're not dealing with an area where reasonable minds can reasonably differ. And we need to give guidelines and guidance to police officers, or in Taylor v. Riojas, I think it was correctional officers. This is an area where no reasonable corrections officer could have thought that torturing someone for weeks is somehow okay. No reasonable officer could have thought that. So that's the black area. That's, so you've gone from purest of no gray at all in it white, all the way up to pure just midnight black. And that's kind of the spectrum. So it's intended, qualified immunity is intended to get rid of that first kind of third of the losers. And it's also intended that to provide bright lines in the gray area so that cops know what they can and can't do. And if we get rid of qualified immunity, what we're going to have is those roughly third of lawsuits, I'm just throwing numbers out there, will drag that officer through court. And he will get punished for something that's not wrong. And just like it's wrong to drag someone through the criminal court system up to the point where they get in front of a magistrate because you can beat the rap, but you can't beat the ride. Just like in that situation, it's wrong for the police to do that to the suspect. It's also wrong for a plaintiff to do that to a defendant, to any defendant. I'm not trying to carve out special exceptions for police. I'm just saying it's once it's a loser, then it should be wrapped up in favor of the defendant. So those are going to be cluttering up the court system. The gray area ones, they already do clutter up the court system. I mean, that's just the nature of courts. I mean, if you throw a case in front of a lawyer where there's a potentially big payout and he thinks he can make an argument that somehow this is different, or that he should be able to get it, or he should be able to get past qualified immunity somehow, he's going to go for it. So a lot of those gray area ones are still going to go in there. But again, it's going to allow some of the gray area ones where it's clearly established that this is the line. Are you on this side of the line or on that side of the line? If the officer's on the it's okay side of the line, then it goes away. And it should, because again, once it's established that the officer was within the bounds set by previous case law, then it shouldn't proceed, because all it's going to do is waste the officer's money, and it's going to waste the plaintiff's money and time and whatever. It's going to eat up court time, and there's just no real good reason for it. Which brings it all back, because he's saying end qualified immunity, but he hasn't shown that he's brought a lawsuit against the officers, or that Solo Yacker brought a lawsuit against the officer for that 2-minute detention. And even if he had brought it, I mean, it's so clearly within the statute that allows Solo Yacker to carry the firearm is actually a statute that prohibits the carrying of firearms, but there's an exception in it. So the rule is you can't carry firearms, but there's an exception if you're going to or from hunting, camping, or fishing. And so he is literally the exception to the rule as he's walking down the road. The officer stops him, knowing the rule. He has probable cause because there's a rule that says you can't carry a firearm around. And then Solo Yacker says, well, I am actually the exception to the rule. And how is the officer supposed to know that? He was supposed to see the fishing rod that's mixed in with the 2 flag sticks. From behind, it's just magic, I guess. And even so, just because you're carrying a fishing rod doesn't mean you're necessarily going fishing. The officer can infer that, but he also can ask you questions about it to make sure that you are in fact going fishing, which actually kind of leads me to a different thought. I'm not entirely sure that it's beneficial, maybe from a filming standpoint, but if you're not filming, if you're not trying to collect YouTube revenue, it is much safer to not say anything to cops than it is to ask for a supervisor. Because if you ask to speak to a supervisor, you're literally saying, I want to talk to the police, which violates the cardinal rule that lawyers will always tell you: don't talk to the police. So asking to talk to a supervisor seems like it would not be a good idea. Now, again, I don't know your particular motives for doing it. So, I mean, if you think it is more beneficial to you, feel free. If you ask me for my advice, though, I would obviously say don't talk to the police. It's just, there's nothing to be gained from it. And if you think that supervisor, Jeff Gray attached the supervisor talking to the 911 center at the end of it. And was the supervisor mad at the guy who had stopped Solo Yacker? No, he wasn't. He thought that Solo Yacker was baiting the police, and Solo Yacker was. Was he actually going fishing? I guess if you don't fish with the tackle box, maybe he could be, but I would doubt it. Anyway, Anyway, so without actually filing a lawsuit, without having a cause of action, without having any real damages to sue over, I don't really understand why Mr. Gray thinks that it's a qualified immunity issue that officers suspect him of baiting the police or what have you. So, should we get rid of qualified immunity? And again, I would be a plaintiff's attorney. I've never represented a police officer as an attorney, as a defense attorney for a police officer. And normally it would be a insurance company who would be hiring the defense counsel. But I have at least tried to sign up a couple clients to go after the cops for violations of their rights. And so, I would be the guy who would have to overcome the qualified immunity. And I don't think it's as big of a deal as people seem to think it is, because again, what qualified immunity does is it weeds out the losers. And I don't want to be representing someone on a loser case. I would rather go on a winning case where I could win and make hopefully a big pile of money. So having the qualified immunity there doesn't really affect me, because again, it only weeds out the losers. For example, Turner v. Driver, a lot of people think that, Philip Turner should have been able to sue those cops, yada, 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 and that's great. And I understand it. But you have to understand that, would it be fair to you if all of a sudden your employer starts to enforce a new rule that you never even knew about and you violated it before you even learned about this rule? Would that be fair to you? You'd probably say no. And so if you can empathize, if you do have the ability, I know some people don't have the ability to place themselves in another person's shoes and to think what would happen if I was in that position. But if you were in that position, you wouldn't really much appreciate it. And especially considering some of the consequences that could have come. I mean, this could have cost those officers, hundreds of thousands of dollars. But now that they know about it, they don't have an excuse. And now that they know about it, then it's fair game, because Turner v. Driver set the stage. Look, you can't do this. Now if they do it, now you can sue the pants off them. And while it does cost the plaintiff a little bit of money, they're going to file their 12B6 motion, and they're going to assert qualified immunity, and they're going to do all these other things that are pretty standard for defendants to do. It's going to cost the defendant money unless the attorney is working on contingency fee, in which case it would just cost the attorney money. But it's not something that's going to stop the whole process. So again, I don't understand particularly where we're going, and I'm about 20 minutes into this video, so I think I should stop rambling at this point. Thanks for watching. Have a great day.